After an interview, if you're interviewing multiple candidates, I would highly recommend that you put some sort of notes as to why you ultimately selected one candidate. I would also recommend that you don't make anyone any false promises. For instance, let's say you have 10 candidates and you ultimately select one person for the job. Don't tell the other 9 candidates that you'll keep their application on file and reach out to them. The reality is you probably won't, unless you truly are doing that. I don't know many employers that do. Just tell them if they want to, they can follow up. I'm also a firm believer, not just for legal reasons, but more moral and fairness reasons. If somebody's interviewed for a job and they're not selected, write them a short letter and just tell them they weren't selected. A lot of people out there who are having a hard time finding employment are pining away, and if they don't get a response, they may bother you for a long period of time and keep haranguing you to get an answer. So I'd highly recommend you telling them. For those employers out there who do medical tests or physicals, those obviously can only be done after a conditional offer of employment. There is actually a private cause of action. If you ask somebody to have a physical before you even make an offer of employment, they can. Evaluations is a real pet peeve of mine. I know a lot of employers only do annual evaluations. While I don't think they're a horrible thing, what frustrates me with employers doing these is they really become an evaluation of what the employee did. And for instance, let's say you do your annual evaluation the last week of December. It's not really an annual evaluation. It becomes an evaluation of what they've done the month or so beforehand. That's why it's very important to keep notes and documents throughout the year so you can give them a true evaluation of how their performance has been over the entire year. You also, I highly recommend you have an evaluation at least twice a year, and candidly, I recommend once a quarter if you can swing it, because you want to constantly make employees understand how they're doing, where they can improve. Another pet peeve of mine when it comes to evaluations is I always get calls from employers that say, all right, I just received an EOC charge or a lawsuit. This case is complete junk. We didn't do anything wrong. Jane wasn't fired because she's a Muslim. Jane was fired because she couldn't show up to work on time. They then ship me over the personnel file. I look through the personnel file, read the evaluation, and guess what I find out? Jane always received 5s for attendance. Obviously, she had an attendance problem, but the manager or the owner of the company was not honest with her. Nobody's going to improve, and no one's going to meet your expectations if they don't know what they are. I think you're doing a great disservice to both your company, yourself, and your employees if you're not being candid with them on the evaluations. So be extremely candid on the evaluation. Tell them the mistakes they're making, if any. Tell them how they can improve. And I know a lot of people give great evaluations because they just don't like the conflict, and they're afraid if they give somebody a bad evaluation, they're going to get sued, or there's some sort of defamation claim. You're far more likely to win an employment case if you've given someone an honest evaluation than if you always give them a good application and then they're ultimately terminated. So I highly recommend that you be honest on these things. The other things during an evaluation you want to make sure is the employee has an opportunity to sign off and write any comments. The same thing has to do with counseling, and that you sit down with the employee in private. I never recommend counseling an employee in public, just like you wouldn't probably scold a child in public. You want to do those behind closed doors and give the opportunity for the employee to hear what you expect of them and where they're deficient. I also very much expect on counseling statements to say what the expectations are for improvement. For instance, if they're tangible goals. Let's say somebody's not meeting their sales goals. The evaluation should say, all right, you only sold 10 cars in the month of January, where your quota is 15. If you don't meet the 15 quota at the end of February, you may receive more disciplinary action up to termination. I want tangible goals for the employee to meet for improvement, so if the employee is ultimately terminated and decides to file an EOC charge or sues you, we can show the judge or the court or the EOC or the jury, look, we told the employee that if they didn't sell 15 cars in February, they'd be fired, and they only sold 8 in February. That's why they're let go. That same group I told you earlier today, that Wall Street Journal study where over 70% of the people who are in employment juries have it out for employers. Believe it or not, 90% of that same group who was tested say if they see something in writing, they tend to believe it. So therefore, it's very important that on these counseling statements that you are very honest with them and tell them how they can improve and what their expectations are and what very well may happen to them if they don't improve. You also need to be very objective in these things. Uh, the best advice I give in this regard is pretend you're writing for the front page of a newspaper, not the back page, meaning you're not giving opinion, you're not giving an editorial, you're simply stating the facts. Jane didn't show up to work on time 8 different times. As a result, she's put on probation. If she has any more absences in February, she'll be terminated. I've seen some counseling statements and evaluations that would, while they made me laugh, boggled my mind and ultimately were very problematic. Things such as, Jane's depriving a village of an idiot, or Jane's hit rock bottom and continues to dig. That stuff may be humorous, but it can come back to bite you. So be very careful in what you're doing. When you go to counsel somebody, I normally am a proponent of having at least one witness with you so they can verify what was said. You don't want to get into a situation where you can't verify what was said because sometimes employees, believe it or not, will make things up and claim you said, you're being disciplined because you're a female or your religion. So I always recommend having another witness, and again, I recommend doing that in private. Also, make sure that employees, if you don't have an open door policy, either in your personnel manual or employee handbook, I highly recommend you have something like that. You want employees to know they have the opportunity to bring anything to your attention if they need to. So they can bring about any, if they feel that they're being untreated unfairly, you all can investigate. Most of these cases aren't decided about whether or not something unlawful occurred. They're normally decided about how the employer handled the situation and investigated it. So you want to make sure your records are good, they're objective, that if a jury panel or a judge or the EOC looks at them, they understand why you made your decision, and they don't think you're being unfair, and you've given the employee the opportunity to bring any problems to your attention. Now, let's move on to the least enjoyable of the topics, and that's termination. I run into too many employers that make a real mess of terminations. A lot of people are laying employees off right now. And a lot of people are using layoffs as an excuse to do really what is a quote-unquote for-cause termination, meaning you've been looking for an opportunity to get rid of Jane. Now you're finally going to take that opportunity because you're going to couch it as a layoff. Let me give you my top problems people have or how they do terminations wrong. Number one is they refuse or fail to give the employee a reason why they're being let go. Now, you're not required under the law to give somebody a reason. However, if you do not give them a reason, what's going to happen? Well, you probably guessed it. They're going to make up their own reason. And rarely is that reason they make up going to inure to your benefit. Typically, people have a hard time taking blame for their own shortcomings. And if you haven't given them a reason, if it seems like it's a secret or you're hiding something from them, then they very well may come after you. So in a termination, I want you to give somebody the honest reason you're letting them go. Don't sugarcoat something. I'm not saying you need to be mean or cold. I'm simply saying you need to give them the honest reason. The second mistake people make is they really do try to sugarcoat something, or they try to couch it under a different reason. For instance, let's say somebody's being fired for absenteeism or poor performance, and they can't get along with their coworkers. Well, employers might say, well, you're being let go because it's a layoff. And then the employee finds out that a week or two later you replaced them or put somebody else in the position. Well, you're going to get an EOC charge, and that employee's going to say, well, they didn't give me the honest reason. Obviously, the honest reason is something bad or something nefarious. Otherwise, they would have given me the real reason. That's how most of my cases started. Somebody didn't give the real reason why the employee was let go.